Welcome everyone to Asking for a Friend, Mid-Year Election Change Edition. Thank you all for joining us. Kelly Ekman will be answering the questions you send through the Q&A today. We will try our best to answer all of your questions, but if for whatever reason we're unable to get to your question today, please follow up with your advisor for further assistance. Today's presentation is being recorded. We will be sharing the recording in the follow-up email and on the NFP website. If there are any portions of this call that you missed, by Monday you will receive an email with a link to the full recording. The PowerPoint slides used during this presentation will be shared in the same email. At this time, I will hand it over to Doug Lemmerman, Vice President and Counsel of Benefits Compliance at NFP, and Sharon Cohen, Vice President and Counsel of Benefits Compliance at NFP. Sharon, the floor is yours.
Thank you so much, Amber. Greetings from a kind of rainy and dreary Washington, D.C. My name is Sharon Cohen, and I am new to the compliance team at NFP, and I wanted to just give a little bit of my background before Doug and I get started. I began my formative years as an attorney in the Chief Counsel's office at the IRS. I worked on employee benefits, which included cafeteria plans. I was there at the IRS for about 9 years and was part of the team of attorneys who drafted the first change of election regulations in the late 90s. I left the IRS and expanded my welfare benefit horizons by working in a similar role to the one that I have now at NFP for 2 different large consulting firms. In 2020, I took a little break and filled my head with sourdough recipes, but I felt ERISA calling to me, and after spending a year as an account manager at NFP, I moved over to the benefits compliance team. And I started working with this team in January, and I am super happy to be here and part of this great team of attorneys and compliance experts. My colleague, Doug Lemmerman, is with me today. Doug is a litigation and welfare benefits expert with years of experience. He worked for a large TPA prior to joining NFP's compliance team, which was a little bit over a year ago. So he's a little bit senior to me. And Doug and I are really pleased today to talk to you about cafeteria plan elections and changes. Just want to make sure that we are providing the information today as general guidance, and none of it should be taken as legal or tax counsel advice. And here we are. So let's get into it. What is on our agenda today? It's cafeteria plans. And because cafeteria plans shelter money from taxation, there are a bunch of rules from the IRS surrounding them. So for purposes of today's discussion and the publication that we issued on cafeteria plan changes last month, when we mention the rules, we are talking about final. So sorry, we were talking about, so sorry about this, final and proposed regulations, a smattering of notices, and some informal non-binding opinions from a variety of attorneys. But today we're going to talk about cafeteria plans generally, and then we're going to spend the majority of our time talking about permissible election changes. And so I will say up front that there are 3 words that you are not going to hear during this webinar, and they are qualifying life events. Technically, permissible election change events are broader than life events, and a qualifying event, that term, is actually specific to COBRA. So as you will see during our discussion today, the events signaling an election change can occur for a variety of reasons. Some do, in fact, have to do with life events or family matters, but not all of them. Permissible election change events usually fit within these 4 broad categories that we have listed here. They are change in status events, changes in cost or coverage, HIPAA special enrollment rights, court orders, and other mandates. Now, Doug and I are not the word police, and change is hard, so it is no big deal if we fall back into our old vernacular. But our goal today is to provide you with a better understanding of the concept of elections, election change events, and what is considered to be a consistent change, the consistency rule that we refer to here. And that is an election change is on account of and corresponds with the event's effect on coverage. At the end of this presentation, we're going to run through some examples, and so hopefully everyone will come away with a little bit more knowledge around election changes and mid-year events. As I mentioned before, we did issue a publication at the end of April. That publication is called the Midyear Election Change Events, a Guide and Matrix for Employers. And if you don't already have a copy, you can talk to your account team, and I'm sure they will be happy to send that to you. So now when you think of an employment relationship generally, anything that an employer provides to its employees is considered taxable income unless there's a specific exception in the tax code. And there are specific non-taxable benefits in the Internal Revenue Code, like health coverage and group term life and dependent care. And Congress created this notion of a cafeteria plan to shelter the arrangement where an employer gives employees the choice between cash or salary and a non-taxable benefit like health coverage. Prior to the creation of a cafeteria plan, which is in Section 125 of the Internal Revenue Code, when given a choice between cash, salary, or a non-taxable benefit like health coverage, the IRS took the position that employees who took the health coverage would be taxed as if they had taken the cash. They saw the cash and the non-taxable benefit, when offered a choice like that, to be equivalent. So Section 125 was implemented to shelter that arrangement. And in that way, a cafeteria plan is not a typical employee benefit plan. It doesn't provide benefits directly to employees. It's a vehicle through which employers can fund benefits and employees can choose the benefits that they want, hence the name cafeteria plan. So employees can pick and choose the benefits that they want. If they don't want any benefits, they're going to take home more salary. Listed here, we have a variety of names that ultimately all refer to a cafeteria plan. I'm sure each one of you could add to this list, but you can call it a premium only plan, a POP plan, a salary reduction plan. They are all versions of a cafeteria plan and all subject to Section 125 and have to adhere to those rules. This is a depiction or a picture of a cafeteria plan and all the benefits that can be offered. You can see that salary reduction dollars, as well as other employer dollars, funding the arrangement go into the account, go into the cafeteria plan, and the plan has PTO buying and selling. It also offers a health FSA, a major medical coverage, dental, long-term disability, other disability benefits, group term life, adoption assistance, dependent care. You can see all the different benefits that are offered here. I want to just take a minute here to remind everyone that the IRS considers salary reduction dollars to be employer dollars. The concept is that the employee gives up what would have been designated as their salary before it's actually earned, before the employee has the right to the money. So from the IRS perspective, this money is employer money. I'm going to say that again. The salary reduction dollars are considered employer dollars, and it's considered to be contributed by the employer. So this is one of the reasons why, under the use it or lose it rule for health FSAs and DCAPs, dependent care, any unspent dollars are just returned to the employer because it is considered employer money. So let's get to some of the mechanics for a cafeteria plan. Who can sponsor a cafeteria plan? Basically any employer. Who can participate in a cafeteria plan? Only common law employees of the sponsoring employer. So when you think about a common law employee, this is a person who is directed and controlled by the hiring entity. The employer controls the manner and means by which the work is done. So there are certain behavioral and financial controls. Want to know who's not an employee? An independent contractor. An independent contractor is not an employee. An outside board member is unlikely to be an employee. A more than 2% shareholder of an S Corp, a partner in a partnership, not employees. A self-employed individual, not an employee. And what benefits can be offered? These are also known as qualified benefits, and we list them here. Should you have a written plan that outlines all the terms and conditions of your cafeteria plan? Is this a rhetorical question? Yes, yes, it is. You should have a written plan. The final regulations expressly state that the cafeteria plan will fail, and that means all the tax exemptions will become taxable if the employer doesn't have a written document. And this would be a separate written document from an SPD, for example. They are likely to overlap a bit in content. But remember, the SPD is a Department of Labor requirement, and the cafeteria plan is an IRS requirement. I also want to give a quick shout out to the non-discrimination rules and testing. We are not going to talk about those rules today, but the general notion is that underlying benefits and the cafeteria plan were created by Congress to benefit rank and file employees, not highly compensated individuals. Elections under a cafeteria plan have to be fixed and certain, and they're generally prospective and they are irrevocable. Those are the basis of cafeteria plans. And the rules say that elections must specify the future period for which the benefit will be provided and be made before the beginning of that period. This is why we have an open enrollment period, and then the benefits kick in the first day of the plan year. There's very specific exceptions for certain retroactive elections for a 30-day window for new hires and the HIPAA special enrollment right of a birth, adoption, and a placement for adoption. Elections take all different forms: default elections, affirmative, negative, passive, evergreen, springing. The election has to be irrevocable. So this concept brings forward the idea of what is actually the election. What is it that is irrevocable? To some degree, it's part of a plan design, but you could ask this question: is it that pretext payment that's irrevocable? That's what the IRS cares about, and that's, in my mind, what the election is, the pretext payment. But an employer may decide it's that pretext payment as well as a particular carrier. So they don't want employees to switch between different carriers for any given coverage. The IRS regulations do provide an exception to the irrevocable rule that allows certain mid-year election changes. This is what we're going to talk about today. So to qualify for the exemption, the plan administrator has to ensure that a specific event has occurred, that the event has an effect on the coverage, and that the change that the employee wants to make is consistent with the effect on coverage. This is the key to these rules. There has to be a recognized event, and that change has to be that the employee wants to make has to be consistent with the event. So I also want to quickly clarify that election change events are permissible. They are not mandatory. We think sometimes that certain events are mandatory, like a HIPAA special enrollment, and HIPAA does require that coverage under the group health plan be accessible for certain employees when a specific event happens, like the birth of a child. But it doesn't dictate what can or cannot be done with respect to the pretext payment for that benefit. So the cafeteria plan rules allow that pretext payment coverage to be made for the HIPAA mandated benefit. It's a rule of administrative ease, and most every employer uses it. Finally, I don't want us to forget about any underlying policy, and if it's more restrictive than the cafeteria plan rules. So a cafeteria plan should indicate an election change window. Most plans allow between 30 to 60 days to make an election. Some events, like the HIPAA special enrollment of CHIP coverage, require a 60-day election period. Otherwise, the IRS doesn't specify a specific enrollment window, but the longer the window, the bigger the window, the more difficult it is to determine if the change is because of a specific event or something else, like someone's changed their mind. The IRS has also created this tag-along rule, which allows an employee to add coverage for a family member who previously had coverage or wasn't covered under the group health plan. Before we go on to explore the specific change of election events, I want to take a quick trip down memory lane. For you millennials and later generations, this will be a little history lesson. So the year was 1993. Let me set the scene for you. It's the mid-90s. It was a time of mullets and baby doll dresses and bomber jackets and flannel shirts and those big dolman sleeves that everyone used to wear. And Bill Clinton was president, and he had tasked a group to write and get past healthcare reform. But there were rumors of death panels and a host of other horrors, and the plan failed miserably. But a couple of laws eventually came out of this endeavor, and one of them was HIPAA, which was signed into law in 1996. So HIPAA was put in place to stop some of the injustices that were happening with health coverage, and it was attached to employers, not the individual market. We don't think too much about HIPAA now because we have the ACA, and all the protections that come through the ACA actually initially came through HIPAA. So the cafeteria plan election rules were updated just after the HIPAA regulations were issued. And the goal of the White House at that time was to try to protect employees from losing employer coverage. That was the overriding principle that was implemented in a variety of ways. And if we will look closely at these regulations on cafeteria plans and election changes, and you will see that this policy is exhibited with respect to health coverage. The rules are the most strict when it comes to healthcare elections and dropping coverage. And it's not the first time, and it won't be the last, that the tax code has been used as a point of persuasion to motivate behavior. So let's look at how this policy got implemented and election changes in general. The first up, we have change in status events, and we list here the change in status specific events. And you may note that some of these overlap with the HIPAA special enrollments. Remember that the consistency rule says that the election changes must be on account of and correspond with a change in status affecting eligibility for coverage under an employer plan. So generally, under these rules, health coverage can be dropped or decreased only if the affected individual takes other coverage. The rules are pretty liberal in all other areas, and in fact, with gaining coverage, and you'll see this tag-along rule come into play here as well. There are special consistency rules for health coverage. For a divorce, an annulment, a legal separation, a death, a dependent ceasing to be eligible, health coverage can only be canceled only for the affected individual. When there's a change in marital or employment status, if the employee, spouse, or dependent gains or loses eligibility for other coverage, health coverage can be canceled or decreased only if the newly eligible individual takes the other coverage. For group term life, AD&D, and disability, a change in status event can trigger an election change as designed by the plan. For dependent care, the change in status event can trigger an election change when there's a gain or loss of the tax exclusion. So for example, if my spouse quits his job and stays home, we lose the right to exclude dependent care expenses. And the purpose of dependent care exclusion is to enable parents to be at work. So when my spouse is no longer employed and not looking for a job, I'm ineligible for dependent care exclusion, and I can drop my election. This is a quick look at the matrix that we have in our publication. Again, you can look for a particular event. Let's say we have a question about divorce. You can see that divorce is here and that a permissible election change event, and that the option is available to the employee to drop their spouse once the divorce is legal. Another change in election event is a change in employment status. This event encompasses a change in hours or a change in the work site. And remember that the change in work site must trigger the gain or loss of eligibility. There is a special rule for a reduction in hours below 30 hours, and that would be that would be considered a change in status event. And the special consistency rule would allow the employee to drop their health coverage as long as it corresponds with an intended enrollment in MEC coverage. And that happens regardless of the impact on eligibility. Next, we're going to move on to cost and coverage changes. Again, these rules are the most restrictive around dropping health coverage. The rules are pretty liberal in terms of changing elections for other benefits like dependent care. if there is an insignificant cost decrease or increase, the employer can make that change automatically. And it should be noted in the plan document and communicated to employees, as all of these election change events should be. Note that this event, which occurs for a specific major medical coverage, does not impact a health FSA, and the health FSA election can't be changed. If there's a significant cost increase for health coverage, an employee can increase their election, revoke the election, and receive similar coverage under another option or package, or revoke the election, but only if no similar coverage is available. Again, you can see the object is to keep employees covered in health care. A significant curtailment of health coverage is also an election change, and this is broken into two parts, with or without a loss of coverage. Without a loss of coverage, these are things like an increased deductible or copay. The consistency rule says that the employee can revoke their election and elect similar coverage. With a loss of coverage, this is something like an overall reduction in coverage, not just the loss of one favorite doctor, but it would be something like a small network and the one and only OBGYN practice drops out. The employee can drop their election if no similar coverage is offered. I want to just say a quick note about the IRS position on health FSAs. Health FSAs were created under the same laws that govern self-insured group health plans. In fact, they are considered self-insured group health plans. They have a minimum coverage limit, right? I'm sorry, they have a maximum coverage limit. As a self-insured health plan, they need to have insurance risk associated with them. This is why we have the uniform coverage rule and the use it or lose it rule. These are insurance concepts. So the IRS thinks of the health FSA as a separate benefit not connected to major medical coverage. So many of the election change events, even though they impact the major medical coverage, it may not have an impact on eligibility for the health FSA. It's a separate and independent election. It's its own entity. Here is just a quick look at the matrix. You can see we provide some examples about significant coverage curtailment. So let's talk briefly about addition or significant improvement of a benefit package option and a change in coverage under another employer's plan. If a benefit has been improved or there's a change under another employer's plan, the consistent election change is to take the new option. Again, this doesn't apply to health FSAs. Two additional changes on this slide: loss of group health coverage sponsored by a governmental or educational institution, and change in coverage available in the ACA marketplace. For the loss of health coverage sponsored by a governmental or educational institution, the consistency rule says you can add the coverage under the employer plan. One time I got a question about an employee's spouse being released from jail and could they add their spouse onto the employer's plan? And I felt like it could fit into this first topic, the loss of group health coverage sponsored by a governmental institution. For a marketplace open enrollment or special enrollment periods, a consistent change is to drop group health plan coverage if the employee intends to enroll in the marketplace coverage. Here we have HIPAA special enrollment rights. So remember that there's an overlap with many of the change in status events. This impacts only coverage that is subject to HIPAA. That would be major medical coverage and any integrated dental or vision plans. For all other benefits like a standalone health FSA, a standalone dental and vision, group term life, dependent care, the change in status rules would have to apply in order for the individual to change their election. The only permissible retroactive coverage is for the birth, adoption, or placement for adoption of the child. Not everyone is like my husband, who called the health plan from the delivery room. I think they were the first people to find out about the birth of our son. So HIPAA mandates that at least 30 days to provide notice to the plan after the event has to be permitted. And the tag-along rule that we talked about earlier would allow the employee to add any other children who had not been previously covered. For marriage or loss of coverage, the election must be prospective. I have seen all kinds of strategies to try to get coverage to begin on the date of the marriage, like a springing election, and I'm not sure that any of these really work. In addition to a special enrollment that is available for a loss of eligibility for Medicaid or CHIP coverage, as a result, and also as a result of gaining eligibility for state premium assistance under Medicaid and CHIP. These are also a special enrollment right. So employees under these rules have 60 days to notify the cafeteria plan about the loss of Medicaid or CHIP coverage, so they can enroll in the employer's group health plan. Now, just a quick word about the 60-day notification period. During the COVID emergency period, state agencies didn't terminate people's Medicaid or CHIP coverage. That policy ended on March 31st of 23, and state agencies began, and they are still doing it, processing terminating coverage for those individuals who are no longer eligible. Last year, CMS, Department of Treasury, and the DOL released a joint letter to group healthcare sponsors asking them to consider extending special enrollment periods under their plans for individuals who lose Medicaid and CHIP coverage, so that they can be allowed more time to enroll in either the employer's coverage or the marketplace coverage. And I'll give you an example. Sometimes the individual doesn't even know that they've lost these benefits until they actually go and seek coverage. So CMS has provided a temporary marketplace special enrollment period that started March 31st, 23, and goes through the end of July 31st, 24, for individuals losing Medicaid and CHIP coverage. And we actually have seen an uptick in questions about the loss of Medicaid coverage, and sometimes individuals are outside of that 60-day window. So an employer might want to think about expanding that time period. Here is just a quick look at our special enrollment matrix. And now I'm going to turn it over to Doug to lead us through the rest of the slides and then take us into the examples where we're going to discuss the most frequently asked change of election questions. Doug?
Okay. Thank you, Sharon. Now I'm going to go over 6 or 7 other events or situations that would allow a mid-year change in cafeteria plan elections. And then Sharon will come back and we'll go over those examples. So first off on this slide, of judgments, decrees, and orders, this is essentially just some type of court order that requires a health plan to cover a child or children of an employee. And it's just for children and not spouses. They don't order people to cover spouses. You'll frequently see these in divorce, separation, or changing custody situations. Employers will find out about these when they receive a qualified medical child support order, which is what we call a QMSO, or a national medical child support order. Both of these forms are for the same purpose, to put a child or children on a medical plan. If the health plan covers dependent children, it must comply with the terms of the QMSO because it's a court order. So this change event allows the cafeteria plan election to change to accommodate the change in coverage by adding the child or children. So this event should always be included in the cafeteria plan document. If the health plan requires the employee to be enrolled to cover dependent children, then the employee may also enroll if not already enrolled. Let's see, the plan must continue to cover the child until it receives another order that allows the plan to discontinue coverage or until the child is no longer eligible. And next one there, slide 21, Medicare or Medicaid events. This event is also included in the regs, so it's very well set out. Essentially, if an employee, spouse, or dependent loses Medicaid or Medicare coverage or becomes entitled to Medicaid or Medicare, then the plan may allow the employee's cafeteria plan election to be changed consistent with the event. That is, drop coverage for the person becoming entitled, or adding coverage for the person who has lost Medicaid or Medicare coverage. You don't see many people losing Medicare once they've enrolled, but you do sometimes see people going on and off Medicaid because it's based on income. And following up on what Sharon just said, particularly since the hold on Medicaid terminations that was part of COVID national emergency ended. As the slide notes, the regs specifically mentioned becoming entitled to Medicare Part A and B, but not Part D. But it seems likely that this event would also include enrolling in Part D. This event is similar to HIPAA special enrollment event that Sharon went over, losing Medicaid. But the HIPAA event requires that the employee be given at least 60 days to give notice to the employer. And this one is not specific about the time limit. And the special enrollment event only applies to losing Medicaid and enrolling when that happens. And this one applies to gaining or losing Medicaid and adding or dropping as a result. Next one, 22. This one's got FMLA and 401k election changes. These two are pretty cut and dried and don't need a whole lot of discussion. When an employee goes out on FMLA, they may keep their coverage under the health plan if they are already covered. And FMLA offers 3 ways the employee can pay for the coverage while they're on leave. But an employee may also drop the health plan coverage when they go on leave or stop paying for it during the leave. And the employer has to offer the coverage back to the employee when they return from leave. This event allows the cafeteria plan election to be changed both to drop the coverage when first going on the leave and to add coverage when the employee returns from leave. And about the 401k, this is mentioned here because changes in 401k elections are specifically mentioned in the regs, and I think it was on one of the earlier slides that Sharon went over. But 401ks, like 403bs for public schools and nonprofits and 457 plans for state and government employees, are generally not paid through Section 125 cafeteria plans for a variety of reasons, so we don't really go over that in this presentation. Slide 23, the changes in HSA elections. We're going to go over a few events that are not in the regs, and I know that Sharon said that the list of recognized events in the regs is exhaustive, meaning that these are the only events that can be used to change elections, but there are always exceptions to the rule, and that's what these next few are. For HSAs, almost all HSA contributions are made through a pre-tax cafeteria plan because of the tax savings for both the employer and the employee. But why isn't it not in the regs? Probably because HSAs were created after the regs were issued, so different rules apply. So no use it or lose it rules like FSAs and DCAPs, and you don't need an event to change elections. Essentially, the owner of an HSA who has high deductible health plan coverage and no other non-high deductible health plan coverage or Medicare may change their election at any time without any reason or event. But if an employer is facilitating the contributions through payroll withholding, the employer may limit the frequency of changes, but no less frequently than once a month. Slide 24. Informally recognized change events. The 3 on this slide are also not in the regs, but representatives of the IRS have acknowledged informally, which means that they might have said it out loud at a seminar or presentation at some point, but they'd never written it down, that these would be allowed. Mostly it just makes sense to allow them. USERRA, that's the Uniformed Services Employment and Reemployment Rights Act, is when a reserve or National Guard member is called up for active or reserve uniformed service, which actually happens more often than you think. If the service member is covered under the employer's health plan, the employer must offer continuation coverage similar to COBRA, but the maximum duration is 24 months instead of 18. But the employer should offer both to the employee. And similar to FMLA, the employer must allow the service member to drop coverage when their service begins, and they must allow the service member to re-enroll when the service member returns. The leaving for uniform service and the returning from service are the events that would allow a change in cafeteria plan election. Next, non-discrimination. Excuse me. This one is allowed to help an employer's plan pass the Section 125 non-discrimination tests. If the employer tests the plan prior to the end of the plan year, which is what we recommend, and the plan does not pass due to highly compensated employees using a disproportionate amount of the benefits, then the plan may reduce the HCEs, I'm going to call them HCEs, elections unilaterally, so the plan will pass the tests at the end of the year. This is not a voluntary change by the HCEs. The plan may reduce their elections consistently among the HCEs with or without the HCEs' consent. And finally, mistakes. This one technically isn't even a change. It's a correction of a mistake that happened in the election process. The idea is to return the employer and the employee to the position they would have been in the mistake had not happened. If the employer has clear and convincing evidence, which is a very high standard, that a mistake has been made, the employer may correct the mistake even retroactively. In the event of a mistake by the employer or the employer's vendor, a mistake is pretty easy to spot. It's usually a data entry or a transfer error that can be shown by inconsistent paperwork of some kind. But when it's an alleged mistake by the employee, the employer will need to have a good evidence that a mistake occurred and that the employee isn't just having second thoughts. Some things the employer might need to consider include when it occurred, when it was discovered, the employee's past elections, the time elapsed since the first payroll date after the election was enforced, and any other relevant evidence, and there might be a lot. The easiest situation is when the employee could not have been able to benefit from the election, like when the employee elects dependent care but doesn't have any dependents. Others are more difficult to decide, and actually we have a more difficult situation in the examples after this slide. Ultimately, it's up to the employer to decide by clear and convincing evidence if the mistake has occurred. Some employers don't want to get into potentially subjective decisions, so they don't allow changes based on employees' mistakes. If and to what extent the plan will allow corrections of mistakes should be set out in the cafeteria plan document. Good communication in the enrollment process and getting enrollment confirmations before the plan year starts will help reduce the likelihood of mistakes like these happening. And now I think Sharon can come back.
Hello. So let's talk about some questions that we get. We actually surveyed our team because we answer a lot of questions on election changes, and we came up with 5 of the most frequently asked cafeteria plan election changes. So in a survey, we found that the top 5 change event questions relate to a change in residence, a change in marital status, a gain or loss, and I think what we talk about is a loss here of Medicaid. Oops, someone made a mistake in elections, that's a big one. And affordability. Somebody can't afford the benefits that they elected. So Doug, let's get into it. This first question. Nutmeg Inc. has an employee who married on October 5th of 23. At that time, the employee's spouse lived out of the country and the employee didn't add coverage for the spouse. The spouse has now relocated to the US. Would this relocation constitute a permissible election change event that would allow the employee to change their election?
Well, there, I see you flash up the considerations, and that's what you got to go through on this kind of a question. It's and I think after you go through all this, it could take a while, but if you go through all these possibilities, then I think the end result is going to be no. The answer to the question is going to be no. Let's look at the way you analyze it. What election events occurred? You know, the first thing you think of is it's a change of residence. This person is changing their residence to move into the country from some other country. Mm-hmm. They were recently married, but not that recently. It's been 6 months ago. So the opportunity to enroll by adding a spouse is probably passed. So the question is it is obviously it is a change of residence, but is it the kind of change of residence that's anticipated by the regs? If you look at the matrix on that, you can see that the change in status must trigger eligibility, and so the question becomes, at least one of the big questions becomes, has the spouses from the other country coming in, has that person's eligibility changed when they moved into the country? And that, I think, would have to depend on whether the plan makes residence in the country a required element of eligibility. And I don't know too many plans that actually do that. If it actually did specify that, then it might very well trigger the eligibility. But I'll ask you, Sharon, what do you think do you think the change of residence was intended to apply to out of the country residences?
I don't think so. I mean, I don't know that couldn't be a situation which would allow a change, but under the plan, I agree with you, that change in residence doesn't make that person newly eligible for the coverage. I think the HIPAA special enrollment right, we asked this question very vaguely, so we don't know, I put this date in here, but if it had just happened more recently, I think there would be a special enrollment right or a change in marital status if it's not a special enrollment right. But you're right, if it's a change in marital status, which is not under the HIPAA special enrollment right category, but more in the change in status category, how long has it been? When did the plan give, when does the plan say you have this amount of time to let us know that you've gotten married? And so I agree that this could be a situation where the individual is not going to be able to add that spouse until the new plan year. I think, though, Doug, that you and I had been talking about a situation where an employer had a policy where they brought people in and out of the country, right? And you had advised them to put in a change in residency like that into impacting eligibility for coverage, right? Is that true?
Right. That's what the situation was. A company that was headquartered out of the country. It was in Japan, actually, and they periodically shuffled managing mid-level managers back and forth as part of their training, and frequently their spouses and family would not follow them for 4, 5, 6 months, and then they would get there. So the timing was off. So I suggested that they change their notice of the change differently so that they could accommodate these spouses that were coming over every 6 months or every 12 months to allow them to become that change of residence with that meta notice. And it worked out pretty well from that point of view. If it's regular, I mean, that's something you might want to do is consider adjusting the rules. But really, I think you can tell me, the only really thing you can do in changing the status change events is change the deadline for giving the notice. I mean, that's the only thing that's left vague, really, isn't it?
It is, but I would agree that I wouldn't recommend doing that. And for most employers, for many employers, this is sort of a very specific situation, that may not occur super often enough to make an entire change to the cafeteria plan to prevent it, to address it, for example.
Yep.
Yep.
Well, let me bounce a couple other possibilities that people might be thinking of if they're reading the matrix for this particular situation. What if you could say that it's a change in the spouse's employment? The spouse was in Bolivia or wherever they were working, living and working, and they lost their job because they moved here. Well, they probably lost their job. They probably quit their job to come over here. I know there's a reason that's not allowed, but what do you suppose it is?
I suppose it's employment within the U.S. I mean, I think those rules contemplated, coverage within employment within the U.S. I don't know how that would apply.
Right.
I think you might be going off the ranch, out of the box. You would need, well, let's put it this way. I would want to seek counsel to tell me what to do there.
Exactly. So, and how about the other one? There is a mention in one of the status change events, loss of coverage under another group health plan sponsored by a governmental institution. Same question. They were covered under a foreign country's healthcare their country's healthcare plan sponsored by their country, and they lost that when they moved here. So what do you think of that one?
I don't think that would apply here either. I was recently immersed in the HIPAA regulations that talk about, a special enrollment where there's been a loss of other coverage, and they are talking about group health plan coverage within the U.S., not a foreign government's health coverage.
Right. Yeah. I can see that too. So you're right. I mean, I'm looking at it from the standpoint of an employer in this situation, trying to find one of those boxes in the matrix to fit this person in And I think the bottom line is it doesn't.
Yeah.
Is that what you're saying? Yes.
Yep.
So unfortunately,
would
this
agree.
person's going to have to wait until the next annual enrollment or
Yes.
some other status, status event.
Yep. Let's see what we've got in example 2.
Okay.
Allspice R Us LLC has an employee who is not currently enrolled in benefits offered under the cafeteria plan. Mid-year, the employee marries an individual who has an 8-year-old child. Can the employee enroll in cafeteria plan benefits, the benefits that are offered under the cafeteria plan? Can the new spouse and the child be covered? So some considerations here. Again, has there been an election change event? Has that happened? I would say yes, it's a marriage. What is the permissible event? I think there's a HIPAA special enrollment right, and I think also there's a change in marital status. Has there been an impact on eligibility for coverage? Yes, there has. The employee has married. They are going to be able, under the HIPAA enrollment right, to add their spouse. And under the tag-along rule, they can now add the stepchild. That's what I'm thinking. What about the benefits other than the health coverage? So for dependent care, I think that would fall under the change in marital status situation. And I'm sorry, not under change in marital status, but a newly acquired dependent now that is eligible to have dependent care expenses run through a DCAP plan. So I think they should be allowed to add the dependent care, and they can add the other benefits too, group term life, disability. Have I missed anything, Doug?
No. And I think you ought to point out that they've seen the matrix there. Those other lines of benefits are mentioned in conjunction with all the allowed events too. So if they have doubts about that, they can go right across the line in the matrix.
Yes, yes. I would want to add that the employee, depending on how the cafeteria plan is set up, may be able to, if the employee had HMO coverage or PPO coverage, they might be able to, in most plans, would be able to switch to HMO coverage, for example, if they had PPO. Any other issues here?
No, that was you gave yourself a pretty easy one. So that's.
Yeah, why wouldn't I here?
Yeah.
Okay, example 3. I will read it for you, Doug.
Okay.
Regino and Associates maintains a calendar year cafeteria plan through which it offers health coverage to employees. An employee has come to HR with an issue. The employee was enrolled in a state Medicaid program, but the coverage was terminated on November 1st. This is a true situation that we had. The employee was not notified of the termination until February 15th of 24. The employee has produced a letter showing the termination as of November 1st, but it is dated February 15th. The employee asks HR if they can enroll in the Oregano and Associates group health plan. What do you think, Doug?
Well, I think this is a very common question, and we've mentioned it before with Medicaid. The employee loses Medicaid coverage effective sometime in the past, but doesn't hear about it until sometime in the future. And in this case, the employee didn't hear about it for 3.5 months after the loss of Medicaid actually occurred. So the question is, can he enroll? So there's 2 possible events that would cover this: loss of Medicaid under the special enrollment rules, and also loss of Medicaid under the loss or gain of Medicare status event. Both of those events, the employee may enroll themselves, but the question is, was timely notice given to the employer following the event? And this comes up sometimes with what plan document actually says, because 30 days is the minimum allowed to give notice for a new baby. A lot of plans just use 30 days for everything if they put in a time limit at all. But of course, 60 days is required for the loss of Medicaid. So, and even in this case, they went way over 60 days for the loss of Medicaid here. So technically, I would say that depending on what the plan document says here, this person is out of luck because, and it's not their fault, they didn't get the notice until 3.5 months after the actual termination. but they did give notice immediately, but that's way after the event occurred. So technically they would be required to deny that person's enrollment. What do you think about that?
Well, I don't like that answer at
I know
all.
you don't like that answer.
I don't like it. I would say, and I think that it could be done, that the employer could allow the 60 days to run as of the date of the notification letter. How about that one?
Well, I like that, and that is something I think that can be changed in the mid-year change events rules. The amount of time of notice given. That's why we're mentioning that before. And if you time it from the date that the notice was received by the employee, that makes a whole lot more sense.
Yes. And also, I do think that this question sort of falls in line with what we mentioned before with the CMS and DOL and Treasury letter that was issued about the state sort of unwinding from these Medicaid opportunities where they didn't terminate coverage because when people became ineligible during that COVID period. And so I do think that this probably has fallen into that conundrum that was created for the last year, right? Because that is a really long time to terminate November 1st and then give them the letter February 15th.
But unfortunately, though, I think that Medicaid is kind of notorious for being slow about giving notice. So make an exception for Medicaid notice, I think, would be appropriate in the plan document.
Yes, and I agree with you to address it in the plan document, especially if it's a common occurrence for the employer.
Mm-hmm.
Okay. So I think I have to show the question. An employee from Parsley, Sage, Rosemary, and Thyme Consulting approaches HR asking for their DCAP election to be corrected. They accidentally elected the Health FSA when they meant to elect the DCAP. Is this a mistaken election that can be undone? And just to know, as my daughter used to say, for the previous 3 years, the employee made an annual DCAP election of $3,000 and a Health FSA election of $1,200. For the new plan year, the employee made a $3,000 Health FSA election and did not make a DCAP election. So what do you do with this one, Doug?
You're going to give me the hard one again, because I think searching the matrix for an event that covers this, I don't think there is one unless you get down to on the bottom line where about the mistake that I went over in a couple slides back. I think he's going to have to argue that he made a mistake, and all he has to go by is his prior elections, and that's certainly something you could consider when you're trying to determine if a mistake's been made. But I think that if this is all the information they have, then I think that it's not clear and convincing evidence to me that a mistake was made. I can see where, the $3,000 is similar year to year to year until they get to the current year, but it's conceivable in my mind that this person's child aged out of dependent care since last year, and he doesn't need dependent care anymore, so he's putting his $3,000 in the Health FSA. It's not a clear one to me, so I think it would be up to the employer, of course, to make a decision here whether or not this falls under the classification of the mistake by clear and convincing evidence. And I think I'd be leaning towards no, if that's all we know about it.
Yeah, I agree. I think this is incredibly vague, right? You cannot really determine whether this was a mistaken election made by mistake, or they changed their mind and didn't really, that procedure, the root canal that they were going to have is not going to happen. And now they want to change this $3,000 Health FSA election. And in years past, they had that amount in the DCAP, right? So I don't think that in some situations we have like an impossibility. We have a child that has aged out, and they can't possibly use the money, right? And so there it is more, it is more reasonable to say they made a mistake. The boxes were next to each other. They never intended to take a benefit that they couldn't receive. But here, you can't really tell if that is the case or if they just changed their mind. And so I think it is important for employers to kind of think about how they want to handle mistakes before they happen. Have a written policy about how those mistakes will be handled so that anyone who steps into the HR office is going to know how to do that, right? And that they treat all employees uniformly as opposed to sort of a one-off situation, because employees talk to each other, right? And so I do think that it's really important to have some kind of policy. It doesn't necessarily have to be something that they provide to employees about mistakes, but just uniformly within the front office, they know how they're going to handle mistakes like this. And I would agree that it is not super clear that this was not someone changing their mind. Any other issues with this?
No, I agree that I think they ought to have written procedures on that and record them, obviously, and be consistent with them when they make the decisions, particularly on mistake, which is really a subjective thing.
Yeah. All right, last one. An employee has come to the HR department asking to drop their health coverage due to financial hardship. The employee has presented credit card statements and outstanding bills showing that they cannot afford the payroll deductions. Can the coverage be dropped? What possible penalties would the employer or the employee face? And I guess this is my question. It's not so easy, Doug. So
it's an easy one. I know you're not going to like the answer, but it's an easy one.
Yeah, I know. So this is why we have written procedures and why we say, I mean, first of all, you have to have them, but it's clear that you have these written procedures and that you have communicated to employees about about election changes, that they make these elections, they are fixed and certain and can only be changed in limited circumstances. And unfortunately, financial hardship is not one of those. Now, anybody in the HR office should not be looking at credit card statements or any outstanding bills. That is not anything that someone in the HR department should be doing, because the truth is it doesn't matter. Affordability is not a change of election event. And unfortunately, this employee cannot drop their coverage. Again, it's sort of uniformly treated for everybody the same way. There is no impact on eligibility for coverage, and it's not a permissible election change event. What do you think, Doug?
I think that's true, and I think that we do get these, and I think the only reason we get these questions is because the folks in the HR department really don't want to force this person to keep on the plan. They want her to get her money back because she's got financial problems.
Yeah.
But there are alternatives to or financially assist an employee without making federal rules, because like on the bottom there, the considerations, what might happen if you start knowingly break the rules, including in the mid-year change events, you might very well disqualify the plan and everybody's benefits will be taxed.
Exactly. Whoops, so sorry. So just want to quickly run through that there are a couple takeaways from here. Elections are fixed and certain. They're established prior to the plan year. There are an exception to this general rule. We've just gone through this. Don't forget the formula: specific event plus consistency equals a permissible election change. Mistakes can happen. The employer should establish a strategy for handling those mistakes. Written plan document should encompass election change provisions as well as all the other cafeteria plan requirements. And don't forget to ask your account team if you want to take a look at the new publication with any questions that you might have, and we're happy to help wherever we can. It was a great pleasure to speak with everyone today, and Amber, I'm going to turn it over to you.
All right. Well, thank you, Sharon and Doug, for sharing your valuable time and expertise with us today. To reiterate, today's presentation was recorded. We will be sharing the recording in the follow-up email and on the NFP website. If there are any portions of this call that you missed, by Monday, you'll receive an email with a link to the full recording. The PowerPoint slides used during this presentation will be shared in the same email. At the end of this call, a survey will populate in a new window. Please take a brief moment to complete the survey, as it lets us know what topics are important to our listeners and helps make our education program as current and relevant as possible. That concludes our webinar for today. Thank you everyone for joining us, and have a great day.